Ms. Kavita, may I request you to begin the webinar while the rest of the attendees can continue to log in? Over to you, Ms. Kavita. Thank you so much.
Thank you, Akshay. Good afternoon, everyone. Hope you're doing well and staying safe and healthy. And thank you for sparing your valuable time to be a part of this event, who stitches it anyway, a global dialogue on IPR with regard to fashion and more. I will read out some house rules for this session. Attendees may please place all their questions in the Q&A box visible on your respective dashboards. Please mention your name and company name along with your question. Please also mention name of the speaker to whom the question is addressed. We will have a live Q&A around at 2:45 p.m. and you may use the raise hand icon if you are interested to ask your questions live. In the interest of time and more questions, we will prefer questions coming into the Q&A box. And please have a look at your chat box where the webinar help desk will be posting updates regularly. Now I would like to introduce our partner and head of Hyderabad KNS office, Dr. Goutam Bhattacharyya. Goutam is a patent attorney and heads the Hyderabad office of the firm. He handles patent drafting and prosecutions in the fields of life sciences. Dr. Goutam represents several multinational and domestic corporations on a variety of IP issues and works very closely with several startups and spin-off. He also assists clients in issues related to patentability, licensing, due diligence, and IP strategy. Goutam has significant experience and a proven track record of assisting biotechnology and biomedical startups, providing strategic advice on filing and best practices in addition to pure patent prosecution. From past for few years, IM Strategy 300 and IM Patent 1000 recognized Goutam as the world's leading IP strategist and leading patent professional. Requesting Dr. Goutam to please deliver welcome remarks and introduce speaker as per the session flow. Dr. Goutam, over to you.
I'm on mute.
You're on mute, Dr. Goutam.
Yeah. Thanks, Kavita, and thanks, Akshay, as well. So, welcome all, and just for the context setting purpose, in recent years, intellectual property rights have played a pivotal role in the growth of highly competitive global fashion industry. And I was reading an article just for a statistical purpose. Fashion industry generates more than $2 trillion per year. Amazing. Amid rapid advances in information and communication technology, supply chain logistics, then social media, then evolving buying culture, IP rights and their protection are likely to become even more central to the fashion industry. So today we have this global dialogue on a topic entitled "Whose Stitch Is It Anyway?" Very innovative title. We have two sessions to discuss various aspects of IP in fashion. In the first session, what we'll do, we'll hear from our Italian, Chinese, and Indian attorneys on protection and enforcement of trademark and design rights, with a special reference to fashion industry. So we have two friends, one from Italy, Elisabetta, and Spring from China. They will have 25 minutes each to present their slides. And Ashish and Bhawana will speak on Indian perspective, will have 15 minutes each. And then we'll come to the second session, where we have a panel of eminent speakers from industry, and we'll be discussing on various aspects of IP protection in digital world. And let me introduce the speaker before we proceed with the special address of Dr. Vandana Narang. Let me read out from, Spring Chang, named the world's leading intellectual property lawyer by Chambers and Partners. She is a founding partner who has advised and represented hundreds of major electronic, consumer, pharmaceutical, apparel, and jewelry companies in Chinese market, as well as Chinese companies overseas. Chang is well known for representing Best Buy in a precedent-setting trademark case that prompted China's Supreme Court to re-evaluate the kind of evidences to consider in IP decision. She has been regularly recognized as leading lawyer by several leading IP publication houses. She will be today's second speaker. And the first speaker is Elisabetta Magni. She is an Italian and European trademark attorney and European design attorney. Elisabetta, after earning Juris Doctor at University of Milan and undertaking the bachelor thesis in IP law on trademark exhaustion in European Union, she has always been working in the IP field in many renowned Italian IP firms. She also worked in-house for 5 years at Firm Group in Italy before returning to the private practice and joining Gregorj IP firm. Presently, she provides advices to national and foreign clients as to IP matters, to the management of trademark portfolio and enforcement of trademarks. She is entitled to represent client before Italian Patent Office, European Patent Intellectual Property Office, and WIPO, World Intellectual Property Organization. And she handles filing, prosecution, opposition, cancellation, and also negotiate settlement and draws up agreement. Now, Ashish Marbaniang is a partner at KNS, and his practice focus is trademark, copyright, geographical indication. He counsels and develop enforcement strategies in case of anti-counterfeiting, criminal enforcement, border protection, customs, infringement, passing off, and domain name dispute. He frequently appears before district court, high court across India, as well as Supreme Court of India, custom authorities, intellectual property appellate board, and trademark office. He actively participate in intellectual property right training program for the police. I know he had been to Hyderabad at least half a dozen times to train the Hyderabad Telangana police, customs, and judiciary. He is currently serving as a member of Internet Committee of International Trademark Association (INTA) for 2020 and 21. And Bhawana joined KNS post her master's in mechanical engineering. She handles patent drafting and prosecution in the areas of mechanical and automobile engineering, design engineering, manufacturing, electrical and electromechanical. She also handled design, filing, and prosecution in India and globally. Now, we are honored to have Professor Dr. Vandana Narang, Dean Academics at National Institute of Fashion Technology, with us today. May I request Dr. Narang for her special address? Before she joins, let me introduce her as well. Dr. Vandana Narang embarked on her career at National Institute of Fashion Technology in January 1995 and is currently the Dean, NIFT, and Campus Director Delhi, and also a professor in Fashion Design Department. She has also held position as chairperson of Fashion Design Department and head projects at NIFT. Her research and publication are in the field of pattern making and has written several books on pattern making. The area of her PhD was men's wear pattern development. Her other interest in the field of zero waste pattern development, Indian pattern making. And welcome, Dr. Vandana. And over to you, ma'am, for your special address.
Thank you, Dr. Goutam, for this wonderful introduction. But I'm feeling totally out of space because I'm not a lawyer by profession. I'm a person who helps designers become designers. So I don't know what you are looking for me for to address the audience and the panelists. Let me just brief you a bit about what is NIFT, because we have some international lawyers who help people develop their patents. NIFT started in 1986 as a premier institute of fashion management and technology. Fashion technology, teaching design, management, and technology, and has been a spearhead institute for in this field. I would not be wrong to tell you that wherever NIFT has set up its campus, fashion industry has followed, and that same is true for Hyderabad too, from where you are. For last 34 years, NIFT has been contributing significantly to the textile industry in design, management, and technology, and not only been a premier institute in starting these courses, we also teach our students the need for IPR, the need for having their patents in place, the need for protecting their designs, and need for protecting other people's IPR also. So we started a course in IPR about 10 years back for making the designers, the technologists, and the management students aware of what their responsibilities are and what their rights are. So when this opportunity Akshay asked me about this thing, and I said yes, we would be interested in holding it because we hold very, very importance for IPR. NIFT has contributed significantly to the design ecosystem or textile ecosystem. I wouldn't call it design, because 70% of all managerial positions in the textile industry in India is held by a NIFTian. I'm not an IPR expert or a patent expert to give any contribution to that, except to say that we definitely need to have the IPR and the patents protected. And very glad to see so many people who help the designers and management people contribute, help them in making their patents possible. I wouldn't take more time because I'm not an expert and I should not take time out of your expert sessions. Thank you, Dr. Goutam, for this opportunity.
Thank you, ma'am. And now I would request Elisabetta to start your presentation. Over to you, Elisabetta.
Good afternoon to every of you. I just a few minutes to thank you, Let's Witness and KNS for organizing this event and for allowing me to take part too. So I was requested to provide the audience of some insights and overview of trademark protection and trademark enforcement in my country, in Italy, of course. And I will give also some very, I might also add some very information, I hope useful, also from the EU perspective, since, as you know, Italy is part of the EU, but there are the legislations of Italy in terms of intellectual property is harmonizing, has to harmonize with EU legislations, but there are still some differences also between legislations in other EU countries if compared to the EU legislations. I'm now going to share the screen, so concerning my presentation. Okay. So first of all, I think that I know that the audience, people belonging to the audience are already well prepared and aware of IPR matters, but still I think, I mean, that a good starting point is to have a rough idea the matter. So in Italy, trademarks, which kind of trademarks can be applied for? The different kind of trademarks are provided for by the Industrial Property Code, which was set up in 2005, and there has been recently in 2019 an amendment. So the kind of trademarks which can be applied are indicated in a special article of the Italian Industrial Property Code, and they can be different. They can be words, personal names, drawings, letters, numerals, sounds, the shape of goods or packagings, color combinations or tones. And but there are two requirements. So the first requirement is that these signs have to be eligible to distinguish the goods or services of one enterprise or one company from the others. And the second requirement is that they have to be representable on the register in a manner which enables the authority and the public to determine clearly and precisely which is the subject matter of the protections. The second requirement has just been introduced by the amendment of the legislation in 2019. So these kind of signs which can be applied for and be granted protections as trademarks are the same as those provided on the EU level by EU IPO. In short, as I was telling, as far as the fashion industry is concerned, of course, apart from word marks, word and device trademarks, I think that's very important to understand for the audience. If you can apply also for three-dimensional marks, I just put on my slides some examples of some three-dimensional marks applied for. So for perfumes, the shape, for article of clothing, for jewelry. And another kind of marks which to me the fashion industry has to take into account is the position mark, also for perfumes on the packaging, for jewelry, for article of clothes. So, and also the pattern marks, which are very common in the fashion industry. These kind of marks have just been recently introduced by the Italian legislation, so starting from last year. And the one that I showed on my slides are indeed, marks, pattern marks, three-dimensional marks, and position marks filed at the EU IPO, where it has been a longer practice to apply for these kind of trademarks. One also very important mark is color marks. Then there are some marks, movement marks, multimedia marks, which are maybe not so common to be applied for in the fashion and luxury field of business. And then the holograms. As far as the filings, in Italy, you can file either on the national level before the Italian Patent and Trademark Office, or you can apply for a UTM application, which is valid in all the countries belonging to the EU. So up to now, still 28, and as from January the 1st, 27, without, of course, the UK. And you can also claim protection in Italy through international trademark registration, covering my country. And so as far as the filing on the national level is concerned, I have uploaded the information available on the website of the Italian Patent and Trademark Office. So the number of trademarks filed, which comprise also the renewals. In Italy, the protection of trademarks is of 10 years, starting from the filing date. As I was telling you, there are some requirements for signs to be eligible to be granted protections. The main important is novelty, and then which means that it will not up to the Italian Patent and Trademark Office to ascertain whether there are other third parties prior rights, but it will be up to the single owner, whether it's a physical person or a company, thanks to a watching service to understand, to ascertain whether other subsequent confusingly similar trademarks are applied. This is the same on the EU level, so it's not up to the office. So there is the citation of prior rights is not provided for either by the Italian law or by the law on the EU level. And another very important requirement is the distinctive character. So the signs needs and has to be eligible to distinguish goods and services from originating from one enterprises from the others. And so according to the different fields of business and to the different goods and services which are claimed upon filing, the distinctive character, of course, has to meet different requirements. So the sign doesn't have to be entirely descriptive of the goods, or also to be deceptive and misleading about the origin of the goods themselves. And also the sign has not to be contrary to the law and to the accepted principles of public morality and not misleading the public. So these requirements, of course, when I hope you will, you will be requesting assistance from a consultant, from an EP firm, and they will correctly advise you to whether or not the sign has meets these requirements. And once the application is received by the IPTO, of course, these absolute grounds are have to be checked, and if they are not met, so if there is any issue, an office action is raised. And at any rate, is of course the applicant is of course entitled to file a brief in reply to try to overcome the examiner's opinion, and there is always a first instance and a second one. So if the decision of that the science is not endowed with all the requirements and cannot be registered as a trademark is confirmed, then the applicant has still the possibility to file an appeal at the Board of Appeal. So that's valid in the examination phase as well as in the opposition phase, always two instances. And so how do you apply for a trademark? Of course, I mean, even Indian companies could apply for a trademark in Italy, or of course at the UIPO without the assistance of a representative. But of course, I deem that relying on the assistance and on the expertise of a professional located in each jurisdictions can make the proceedings smoother and of course more cost efficient, because you can avoid some pitfalls and be properly advised. So there's a form as it's in every jurisdictions, you will have to indicate the applicant, the trademark, the classes. In Italy and also on the EU level, the NICE classification applies, and nowadays it's recommended to apply for a very detailed list of goods and services. And I think, I mean, I've been working in-house, not exactly in the fashion field, in fashion environment, but this kind of advice apply everywhere. So in every field of business. So my suggestion is always to indicate properly the list of goods and services, to think about what's the actual interest of the company, but at the same time to foresee some potential expansion of the business. Because once the application is filed, and that's valid in Italy as well as in the UPO level, what you can do, what the applicant can do, is only to limit and restrict the list of goods and services. You cannot add additional items. If you have to add an item, you will have to refile the application. So think about the actual scope of protection of the business, but at the same time foresee some potential expansion. And not to claim, I mean, we do not advise the client to claim all the 45 classes and the goods falling into the 45 classes, because at some point you might be requested to furnish evidence of use of your trademarks. It will not be up to the office. So it's not like in the United States, which at a certain point you are requested from the office to provide the office with evidence of use, but it will be up to third parties if they want to cancel your prior registration to apply for cancellation actions for non-use. The trademark have to be used within 5 years from the registration date. So overall, considering that both in Italy and the EU, you usually file for an application and it's granted in around 1 year, 12 months, 18 months, depending on how the proceedings goes, plus 5 years from registration to provide evidence of use. So all around you will have 6-7 years. That's to be on the safe side, to understand how the proceedings goes. And another advice is always to file for the mark as the company, as the applicant intends to use it. And always my recommendation, it's a very strong one, to keep track of evidence of use. So of the packaging, of I don't know, of promotional material, of invoices, and just to be on the safe side, that in case after 6-7 years you are and cancellation actions for non-use or other kind of actions are brought against your company, you have already in your dockets, in your premises, evidence, because collecting evidence implies high costs, both from an economic point of view and also from a time point of view, so in terms of time efficiency. So I was telling you in Italy, it's the absolute ground examination takes place, then there is the publications, and once the trademark is published, the third parties, owner of prior rights, might decide to file an opposition against the subsequent confusingly similar application. So this is 3 months from the publication date is the term within which third parties might file an opposition. This term is identical on the Italian level and on the EU level. This is a peremptory and unextendable deadline. I'm aware that in other countries, for instance, in the United States, you can apply for extensions of time. Also in the UK, you can apply for extension of time. But in Italy, it's not possible, and before the IPO, it's not possible. So in case of a straightforward case, usually an application matures into registration in 15 months. And how about if an opposition is filed? So ever since possibility, ever since 1996, when the EU trademark registration was provided for by the law, on the EU level, it has always been possible for third parties to file oppositions against the subsequent EUTM applications. In Italy, unfortunately, this possibility, this remedy was not available until 2011. So up to 2011, the only remedy that prior owner of prior rights could have was to send cease and desist letters to the applicant of a subsequent potentially confusingly similar applications, and then eventually to go to court, whether in cases in which it was not possible to settle the matter, the dispute. Nowadays, luckily, so it's almost 9 years since the opposition proceedings is in force in Italy, and it's an administrative tool. So before the Italian Patent and Trademark Office, it's a procedure which is autonomous from the judicial one. So there are now two remedies, one administrative and another one judicial. And I, as a trademark attorney in Italy, I am entitled to represent clients before the Italian Patent and Trademark Office in these administrative proceedings. If the case goes to court, so if it's not an opposition, but it's a case court, you will have to rely on the assistance of attorney at laws in Italy. And well, which is the advantage of filing an opposition? First of all, the time, so you stop the application, the registration proceedings, you stop it. Whereas if you go to court, the trademark has already matured to registration, and you have to remove it from the register. And since it's an administrative tool, also the costs connected to these kind of remedies are far more lower than those for connected to go to court. And also the procedure is somehow simple. So which kind of applications can be opposed before the IP Trademark Office, so national applications, but also Italian fractions of international registrations. And when the deadline I was telling you, it's 3 months from the publication date in the national bulletin. And so the grounds, as to the grounds, we have to note that the number of grounds which can be enforced before the Italian Patent and Trademark Office has in these years been enlarged. So before the recent reform which took place in last year in 2019, you could, you could file for an opposition only if you were the owner of a registered trademark or prior application and of some personality rights. But nowadays, other grants have been added. So for instance, well-known trademarks, protected designations of origin, and protected geographical indications. The list of grounds which can be enforced has been broadened as a follow, I would say, of the need to harmonize the Italian law with the law and regulations on the EU level. And nowadays, still, it's not possible to enforce before the Italian Patent and Trademark Office rights which arise from the use of the trademark and from the use of a company name, commercial signs, or domain name. So let's assume that your company has set up, I don't know, a branch in my country, or is using a domain name .it, or has been using the mark in my country without filing for an application. In these cases, the only remedy you will have is to go to court if there is a subsequent application which is confusingly similar. So you will not be in the position to file for an opposition, but still, on the basis of these prior rights, you will be in the position to enforce them before the court. And it will take, let's say, it depends, but usually longer time and higher expenses to be borne. And so, of course, who's entitled to lodge, depending on the different rights, the owner of prior applications, prior registrations of image rights, of well-known trademarks, protected designations of origin, or geographical indications. So how is this possible? So the proceedings is on the administrative level before the Italian Patent and Trademark Office. There are examiners which have been trained by the examiner at the UIP office with the aim of having, let's say, an harmonized, as much as possible harmonized perspective. And so once the opposition notice is filed, the PTO examines whether it's admissible, and it notifies the parties of the opposition did, giving a time, a 2 months deadline for the parties to try to find a settlement if they are interested. If they are interested, they are gonna and they need more time to settle the matter. They might apply for extension of time up to a total of 1 year. And on the EU level, it's the same, but the total period of time during which the negotiations might be carried is longer. Is in total is 2 years. So 2 months, 2 months cooling off after the notification of the deadline, plus extension of time up to a total of 22 months, for a total of 2 years. And the proceedings, the opposition proceedings on the Italian level is more or less the same as on the EU level, with some slight differences. So if the parties do not settle, the opponent is given a term for integrating, for filing a brief in support of his position, and this brief will be notified to the applicant, and the applicant will be given a 2 months deadline to reply, and that's it on the Italian level. On the EU level, on the other hand, the opponent will be given another chance to rebut the applicant's arguments. And as far so it's very important to pay attention on the prior rights that you enforce in opposition proceedings. So if you enforce a trademark registration which has been registered for more than 5 years, in the course of the opposition proceedings, both before the Italian Patent and Trademark Office and before the UIP office, you might be requested by the applicant to file evidence of use. And in case you're not in position to supply this evidence of use, or they will not be regarded as suitable to demonstrate proper use in relation to all the enforced goods and services, the opposition might be rejected. So that's very important, to keep evidence of use and to understand which is the better right to be enforced. And of course, if you enforce in opposition proceedings a trademark registration and you might be requested to furnish proof of use, this means that the positions will be longer and you will have also to bear additional costs for this part of the proceedings, for collecting evidences and for illustrating and for describing the evidence and comment of them and rebut the opponent's allegations. So At the end of the proceedings, a decision is issued, and as I was telling you, there are two instances. The first instance by the Italian Patent and Trademark Office, and then you might file, if you're dissatisfied with the outcome of the actions, you might file an appeal before the Board of Appeal. And if you are dissatisfied also by this decision rendered by the Board of Appeal, you might file another appeal at the Court of Cassation in Italy, but only for law issues and not for issues of substances on the merits. So as far as, this was the first part concerning trademark enforcement. As far as, trademark protections. As far as trademark enforcement is concerned, so I'm gonna briefly outline which are the possible remedies, just to give you an overall idea. So there are several options available. First of all, out-of-court actions. You can always send a cease and desist letter to the applicant, but so putting a pressure on the applicant or on the infringer. But you have always to bear in mind that if you send a cease and desist letter to challenge a trademark and you don't receive any reply, or in case of a negative reply, you decide not to pursue the case, the matter further, the trademark, the adversary trademark, will be considered tolerated after 5 years from the date of receipt of the cease and desist letter. So it's not so, apparently it would be easy to send out cease and desist letters to everyone infringing your rights. But if you don't pursue the matter further, you have always to bear in mind that at some point it will gonna be considered as tolerance. So that's, to me, a very important issue to be taken into account. As far as interim measures, they are mainly governed by the Italian Civil Procedure Code and the Italian Civil Code. So we have the Industrial Property Code, which does contain almost all of the regulations, the laws and the provisions concerning IP laws, but there are some also, some provisions contained in the Italian Civil Procedure Code, in the Italian Civil Code, and some others also in the Criminal Code. And which are the interim measures, the seizure and descriptive orders. And so in Italy, there are special courts which have been set up, and they are devoted with the competencies on these kind of commercial issues and also IPR issues. And they deal with interim procedures and may order description, seizure of the items, or the respondents to refrain from carrying on with the acts, or order the assignment to the applicant of the infringing domain name. And as I was telling you, in case of a conflict with a domain name, you cannot act directly before the Italian Patent and Trademark Office, but you have to go to court. And civil courts may grant urgent measures, so injunctions, seizures, orders for withdrawal of the goods from the market. And that's very good from a procedural point of view, but because usually they're examined and granted quite quickly. And then the civil courts might also order judicial investigations of evidences. There are also injunctive relief, and they are granted in case of urgency procedures and may become final unless any of the parties starts proceedings on the merits. And so proceedings on the merits in case of injunctive relief are necessary only to ask the court to order the infringer additionally to pay the compensations, pay the cost for the publications of the ruling in the newspaper, magazines, and over the infringing goods. And as far as the court actions, there are both civil actions, civil proceedings and criminal proceedings. Civil court actions can be based on absolute grounds, on relative grounds, or on the news. So as I was telling you before, in case of a cancellation actions for no news, up to now, you have still to go to court. in the future, likely starting from 2022, but we still have to wait for some other provisions to enforce the law. In the near future, cancellation actions, the Italian Patent Trademark Office will be competent on cancellation actions for non-use, but not now. Now you have still to go to the court. And
Elisabetta, just
yes.
one thing, if you can conclude in
yes, very, very, very short. Thank you for reminding me of the time issues.
Yeah, thank you.
So yes, so there are also just criminal proceedings. There, I will share with the audience the slides which are available, so you might have a clearer and perspective on this. So there is also the possibility to go to court for criminal proceedings. And what else? There are, I just wanted, since there is the application for the customs, I just want to draw the attention of the audience to the, in my opinion, well, good activity that the fiscal policy in Italy is doing. So these are data which have been rendered available by the fiscal police itself. I just recently attended a conference in these connections. So these are official data. And so last year, the fiscal policy in Italy made this number of intervention and this number millions of seizures for a total amount of billions, 1.7 billions. And as far as the counterfeiting by category is concerned, as you might see, there are also fashion items in the highlighted in green. So, and as far as the origin of the counterfeited goods, you might see I'm talking about counterfeiting, of course, in Italy. These are the main countries from which the goods come from. And the last slides are about the designs, and you're gonna see which are the requirements for filing designs and some possibility of enforcement, the designs, priority claim of the designs, multiple designs. That's another possibility for the applicant to protect their rights. I just want to, as a last very short comment, highlight that I performed some counseling activity on behalf of some well-known pharma companies, and you will not imagine, but even pharma companies are now filing not only for trademarks, for word and device trademark or three-dimensional trademarks sometimes, but also for the designs to protect the packaging of the pharma. So if pharma companies are behaving in this way, why not fashion? Why not fashion? So that's my closing comment, and I thank you very much for listening to my presentations, and I hope you will enjoy all the panelists' speech. Thank you.
Thank you so much. Thank you so much, Elisabetta. Now I would request Spring to take over the platform and share your thoughts.
Okay,
over to you.
Let me share the screen first. Can you see this, Goutam?
Yes, clearly.
Okay, so thank you very much, Dr. Goutam, for having me. You know, this is a very, very unique period of time, a very special period of time in China and also in the world. So in China, we are experiencing a trade war with US, and that affect not only the industry in China, US, and all over the world, and also affect the intellectual property protection practice and the legislation in China. So there are lots of things to update. And on the other hand, different from the angle of Elisabetta introduced, China is for a long time is the hotbed of lots of counterfeit issues. So I think this is a very good timing for me to focusing on 2 points, and what's the current challenge, what's the change in terms of IP law, and secondly, how to effectively enforce your IP right in China in a very cost-effective way. But I still usually follow the title Goutam gave to me. I think the presentation of my title is an overview of trademarks and designs, protection and enforcement in China. Yeah, what happened? So I will separate my presentation to two parts. Part one is, move this. Okay, so part one is how would you protect your intellectual property, trademark or design. So this is a pretty much from the prosecution perspective to give introduction. And the second part is what action you can take if you found someone infringing your IP right. So this is the angle from enforcement perspective, more or less from the marketplace. So let's go to the first one, how in terms of prosecution. Okay, so China IP laws provide sufficient remedy to the infringement of intellectual property. So currently we have China trademark law, China patent law, China copyright law, and the China anti-unfair competition law giving protection to the infringement of fashion industry. For example, you can protect your name and the logo of your trademark in China by registering first. And then if somebody using your mark without authorization or copy your mark by filing application, you can basically file litigation against the infringement, or you can file invalidation, non-use cancellation, or opposition to clear the mark. So that's the trademark angle. And from patent law perspective, if your fashion involving some function, for example, there's some technology feature, you can protect the patent, like a barcode, for example, like some very novel barcode, you can protect it as invention or utility model. And for the overall design, you can protect as design. But we see lots of examples where in China, fashion industry protect their design as a design patent. That's more popular in China. And there also copyright law protect the fashion design. So we can define a design with aesthetic value as a work of applied art. So long this is originally creative. And so long this is this design is with this aesthetic value, you can protect this by utilizing copyright law. And the last part is anti-unfair competition law. This is pretty much like if you cannot find a remedy from trademark law, patent law, or copyright law, you can go to anti-unfair competition law. And I have a very interesting example here, which shows in China, long time ago, there is an anti-unfair competition law protecting the fashion. So actually this case is a very famous one. This case happened in 2004. And this is actually a real estate company. They launched a new real estate project called International Lido City. And when they advertising their real estate project, they have a big billboard, and there's a model there hanging, taking a Louis Vuitton handbag. So for this case, you know, Louis Vuitton sued the two real estate developers. So one is Lido company. So the other is called the Xinhui company. So they defend themselves, saying that there's no misleading because it's a real estate and handbag in different classes, and there is no copyright for the Louis Vuitton bag. So in that case, Shanghai #1 Intermediate Court eventually find the Chinese real estate developers' behavior constituted unfair competition against Louis Vuitton, just because they have almost like a very prominent position there for the bag, and with the LV logo on the bag, which is actually a token for the brand, token design for the brand. And meanwhile, this can obviously raise the taste and the positioning of the real estate. So the court decide the real estate company unduly free ride on the good reputation of the Louis Vuitton company, and the behavior constitute unfair competition. So this is a very earlier case where the fashion industry pursue unfair competition law to protect their right. So that's all about the laws available for protection of IP in fashion industry. As I mentioned, now there's a very tricky time for IPR. You know, there's a China-US trade war, and China is experiencing many pressure from US on how to strengthen its IPR protection. And on the other hand, you know, China's economy is booming quickly. And when we talk about China, we are talking about a great China because of the free trade zone concept. Even China, Hong Kong, Macau, Taiwan has 4 independent jurisdictions that have a parallel legal system, registration and judicial system for registration of IPR and for enforce IPR. But from economy perspective, they're more combined. So we really see, you know, if you launch a new brand in mainland China today, and the second day you can see the fake things in Hong Kong or Taiwan, vice versa. So this is so what I'm trying to say is that when we think about the China market and China IP protection, we should consider the concept of a great China concept. But there are lots of challenges from trademark side. There's a long procedure for enforcement, relatively long procedure for invalidation opposition, but the copycat are very rampant. So, and it's very costly to stop them. And also like China and Taiwan, they both have a local subclass practice, which means even China and Taiwan are the member country of NIFT agreement. They do have their local subclass, which means each international class is further classified to different subclass, and the goods and services can coexist in the different subclass. So this is very unique and can be overlooked by the right owner when they file application. And also we have a Chinese version mark. There is many example where the fashion company, when they launch their brand in China, they launch the English version or the Latin letter version, but they forgot the Chinese version. And then later on, you know, the China consumer or China distributor, for their own convenience, they design the Chinese version and they use that very, very broadly. And when the true owner think of protection of this Chinese version, it's too late. They have to pay a high price to get that version back. And there's another question, is a simplified or traditional or classic Chinese version, because in mainland China, pretty much here we use simplified Chinese character, but in Hong Kong, Macau, Taiwan, or even Singapore and other Chinese speaking area, they use a traditional form, which we call the classic form. So when you're thinking of registration, you need to check with your local agency and which version is better. Even they have the same meaning, same pronunciation, but the writing are very different. So that's the challenges we have from trademark side. From design patent side, lots of clients, they don't do FTO. They just launch the design in China and they confront litigation or cease and desist letter because their design fall into the scope of others' patent protection. So this is one issue we confront from time to time. And they would overlook the design patent protection because they really don't quite clear about what's the subject matter of our patent protection in China. Or you could disclose your design with your Chinese local partner or to the consumer before filing patent, so that in terms of nature of the design patent, it lost its novelty. You cannot protect it in China anymore. Technically, you can still file application because there is no substantial examination, but it's very difficult for you to use your design to enforce your right because the counterpart can easily find the prior use evidence and invalidate your design patent. And there are lots of cases where Chinese manufacturer simply file the patent design patent because there's no substantial examination. They have the right anyway, and then they can record the right at China custom, so as to block the OEM exportation from mainland China to other countries. So these are basically some defects or challenges for the fashion brand owner to think about before they launch their brand in China, before they start seriously about doing business in China. So, so directing at these challenges, what's the corresponding strategy? We think there are actually basically 4 parts to consider. So part number 1 is trademark audit. Lots of fashion companies, they have a registration in China like 10, 20 years ago. It's a very old registration. But considering the new change in terms of whatever subclass, Chinese version, or even the Chinese local business of your company could be booming. So the protection scope or the protection font could not match the actual use in China market. So what we suggest is to do some routine trademark audit, maybe on a yearly basis, to fill the gap, to see where the gaps are. And meanwhile, you can look into the competitors' portfolio to compare and to decide what can be done to improve your portfolio strategy. So this is strategy number 1. Number 2 is copyright protection. Goutam asked me about how to better protect little company, like small companies' IPR from a cost-effective basis. I think this is a very good question. I think not only for small company, even for big company, they have a big challenge on how to control budget and to achieve the best result of protection. So we highly recommend copyright. In China, we call copyright as super trademark. So thinking about if you register 1 trademark in 1 class in China, it's 1 cost. But if you are, if you're thinking of a defensive application, you want to file like 30 classes or 45 classes, even more, then then it's actually lots of cost. So lots of our clients, they register copyright for the award or device mark. So long, because in China, the threshold for register of copyright is very low. So long there some stylized form for the word, which cannot be found from the Microsoft database, it could be copyrightable. So you need to register your copyright to confirm you are the owner of the copyright and the subject word or design is copyrightable. So in that scenario, when somebody copy your fashion brand in some irrelevant class, for example, on furniture or even for pharmaceutical, it's very difficult for you to establish misleading and confusion, but it's easy to establish they're infringing upon your copyright to which you have a special design. But the precondition is that you have to register that in China. China is a member country of Berne Convention and the Universal Copyright Convention. But without the registration, the examiner of the trademark office really don't know whether you are the true owner of the logo is copyrightable. But if you register copyright before China Copyright Office, it's pretty much like the copyright office endorse for you to say this is a copyrightable subject and you are the true owner, even though there's no substantial examination for the copyright registration as well. So when you have a copyright registration, technically we call this as a super trademark. Utilizing this protection, you can stop others from registering your trademark even in the irrelevant classes. So we have a lot of successful cases by utilizing this strategy. So that's the second one. And the third strategy is recognizing of a well-known trademark. I will introduce more about this point, but this is really very helpful because if your trademark is recognized as well-known, technically you can win lots of opposition, and technically you have an advantage in terms of enforcement in the marketplace. Even the local administrative authority, in their opinion, when they decide whether the goods of the trademarks of the parties are similar, they will take the well-known status of your trademark into full consideration. So well-known trademark recognition can give you lots of cross-class protection from the prosecution and from the enforcement perspective. So it's very, very important. It's difficult, but it's very important and it's very helpful. The last part is design and utility model. I would introduce design because of time limit this time. So we do think for fashion industry, actually the selling point is design, but not the brand per se. So the lifespan for the design is very short. Usually you have to launch a new design on yearly basis. So China design patent gave you 10 years protection. So we call this as a 3-dimensional protection, or you call as a comprehensive protection, which means if you have a major design or a very important design launched, you may consider not only from the name of the brand perspective, which is a trademark, but also from the overall design perspective. So long as you keep its novelty, you can register design easily. There's no substantial examination, and you can utilize the design to protect your rights. And for utility model, it's called a little patent in China, which is also helpful. So long as there's some protection of structure or function, you can utilize utility model to protect your design. As I mentioned, like the barcode, some special function, something like that. You can utilize that. I would further introduce a little bit more about the well-known recognition and the design and the utility model and the design in the later page. So for the well-known recognition, I would say that well-known, as I mentioned, well-known mark enjoys broader protection in China and is recognized on case-by-case basis. But technically, if you have one-time recognition, it's very easy for you to recognize another time. So in our case, I will show you later, we actually recognize many times for the same client just because we have a favorable precedent. There are 4 ways for the recognition. So you can claim your trademark is well-known in a trademark opposition case filed in the opposition proceeding before China Trademark Office. That's before the squatter's trademark is filed. You can file opposition. That's a prior registration proceeding. The second way is the invalidation. Before the trademark review and adjudication board, which means when the squatter's trademark is registered and you found it, even if it's too late, you can still file invalidation before China Trademark Review and Adjudication Board. And meanwhile, so long the copycat mark are not in your core class, but in another class, a different class where you have registration, you can file invalidation to invalidate them. But in this point, just bear in mind, the invalidation proceeding is better to be filed within 5 years. Otherwise, you have a heavy burden proof. And the third point is read action. This is actually a very special method in China dealing with the massive infringement situation, which means if you find some infringement in the marketplace, but the amount is not that high, but there's some stalking there, to avoid filing litigation, which could be very costly, you may consider file a complaint, administrative complaint, before local administration for industry and commerce. And when the local administration for industry and commerce, they receive your complaint, they can take administrative read action. And if in the case, the infringing products are different from the trademark where you have a registration, you can claim well-known recognition in that procedure technically. So that's something you can pursue. So the last remedy is a civil lawsuits at the courts, which means when you want to sue some infringer, and it's because the infringer copy your trademark in a class where you don't have a Chinese registration, you can also claim well-known recognition. And if the court justify your claims, your trademark is recognized as well-known as well. How to proceed with this? Basically, the starting point is we have a deal with our client about the effort on this, and then our client need to have a very close communication with their China business to collect supporting evidence of use in China, in mainland China, not in India or in Italy, other country, have to be in China. And from our end, as their China lawyer, what we need to do is to select a proper case by proper case, we mean the counterparty should not be very strong, very big, very aggressive, because we don't want them to defend us very fiercely. And we want to find a property cause of action where they're infringing upon our trade name and where we don't have registration in this class. So it's a very, actually it's a very sophisticated work to pick up a qualified defendant to establish a well-known case. So we call this as a vehicle case. It's different from claiming damage, stop infringement. It's just aimed to establish well-known status. So it's different, a little bit different in terms of direction. And lots of clients would say there are lots of bias. The recognition only given to the foreign, the China domestic company, but it's not true actually. So I will give some example where our firm, this is just I pick in fashion field or relative to fashion field. So actually we help many of our clients recognize their trademark as well known in China. So like Apple, we help them recognize their trademark is well known for 74 times already, because we keeping filing opposition for them, and we request the cross-class protection because the copycat are in different classes copying our brand. And the Formula One, same thing, 80 times already so far. And Skechers is a footwear company, 10 times already. And the Chinese version of Skechers, which is called Sikaiji, this is we have one-time recognition. And they actually, this is color contact lens. Contact lens is a different color. So this is for Johnson & Johnson. We recognize their Chinese version of they IQ trademark is well known in China. Levi Strauss, we have 2 recognition for Levi Strauss, Dairy Queen, Tiffany, Lego. Mead Johnson is actually a baby formula company owned by Mead Johnson. And you can see the red star here. So if there is a red star, this means the parties fight fiercely, and eventually it's the court to decide the well-known status. So all this case go to the court proceeding. So we would say if we find our brand achieve well-known status, it's better for us to recognize our trademarks well-known, whatever at the trademark office or the review board or the local administrative authority or even the court, so that in the subsequent proceeding like opposition, invalidation, or even read action or even litigation, our brand can enjoy a broader scope of protection. So that's the strategy for the well-known part. And for the design patent part, I would introduce that the subject matter for design patent protection is any new ornamental design of the shape, the pattern, or the combination thereof, or the combination of the color with shape or pattern of a product. So in terms of fashion industry, like clothes, like bags, footwear, fabric, accessories, and the package of the clothing and the bags are all the subject matter of design protection. In China, partial design is not protected, which means if you want to protect a part of the design, for example, like the panda head of this design, a part of this, or the design of the head of the shoes, or sole of the shoes is not protectable. So if you want to protect the design, you have to protect the overall configuration. But the good news is that China patent law is revised, and as of next June the 1st, partial design will be protected. So this is a very new change happened recently. Third part is we can, from strategic perspective, we can choose single design application with multiple designs. This is very, very important because lots of a company, when they launch their designs, they launch a similar design like a 10, 20 similar. So technically they can file one single design and claiming this is a similar designs of the same products or products normally sold used in sets under the same design concept. For example, you can have your clothing and footwear and handbag, everything together, combine this somehow to claim, but it also depends on the category. So you can file more design. So this is typically applied to our toy company when they design some toys. It's pretty much the same toy, but with a different, a little bit difference in every single toys. So they can file a design application by like 10 design in a set, but filing a single design application. So as I mentioned, the lifespan for fashion field is very short. It's like a 10 months. It's like every year you have a fierce competition. You have to launch different designs, unless there's some like a classic designs that can be kept forever in the market. Otherwise, you have to launch new. So design patent has the feature of a quick patent name because there's no substantial examination. It takes like 8 to 12 months to issue a design patent. So it can be very, very quick. And also for the fashion industry, as everybody knows, since the selling point is the fashion, but not that much of the trademark or trade name somehow, especially among the young generation. So we think if the selling point for your fashion design is actually design per se, then registered design would be a better choice in addition to trademark. So that's about the creative strategy about design patent. So that's all about the prosecution. I do know there are lots of information to introduce about the protection, but I still wish to stress some, not the general information, but some hard topic about the piracy issue, strategy issue, or the enforcement strategy in a cost-effective way. So from enforcement perspective, everybody know, like India, China is also a very huge country. So the common question asked by our clients is how to monitor effectively across the geographics in China, because China is so huge. So we classify this geographic issue from online, offline, and border protection 3 perspective. So so in China, in lots of industry, at least half of the sale happened online. Online sale is very, very popular in China. So what we are suggesting is that to monitoring and file complaints, differentiate big fish and small fish to achieve the online. So which means in China, there are several very major platforms like Taobao, Alibaba, JD, something like that. So on this major platform, what's your monitoring strategy? Do you hire your own team or outside team to keep searching, finding infringing link, filing complaint, delete them? So that's the question for the fashion industry. And then meanwhile, it's endless, right? Because even you file complaints, there are new pop-up in the platform, that's for sure. So so there's some very simple online infringer, but there's some very big fish there. So they have an underground factory in the remote area like Fujian and Guangdong. They also have a store, small online store. So when we talk about the small, the big fish, we will not simply go to file a complaint. What we are thinking is whether we should dig out the factory, preserve the evidence, push the case to save a criminal, and promote our victory to make sure the big fish is beat hard, so that they will not be a repeated infringer. They will not distribute their counterfeit to small fish, and the other big fish can see this good example. So that's a different strategy from online perspective. In terms of offline, as you can see, we should do market surveillance. So like our firm, this is very special, but it's very popular in China. So like our firm, we have our in-house investigator. So when our investigators, they don't have, they're not busy, they will, hanging in the marketplace, find some clues and they report to our lawyer, and our lawyer will report to our client. So this is called voluntary market surveillance. So I think that's something you should pay attention. And meanwhile, like our firm, we organize a nationwide investigation network, which means if our our informant gave us some, some citing report, and if our client eventually justifies action, we will take action, but we will more or less reward the informant a little bit to encourage them, give us more this kind of citing report, just because China is so huge, you cannot use your in-house to cover every single corner of China. So this is for the market surveillance. And internal reporting, responding and the communication mechanism is also very, very important. So we also see lots of cases where we report this is important clue to our client, and 1 month later, the client say, yes, please go ahead to take action, but all the counterfeits are delivered outside. And meanwhile, the client's local store, local distributor, local business, they are in the frontier. So they can witness the competitor or the infringement even faster than a law firm like us. So what is the corresponding internal reporting system to make sure when the suspicious infringement was found, it can be quickly reported to the client, and there's a quick communication in terms of next step action. So this mechanism is also very, very important. And the third part is training investigators. So because especially for the clothing industry in China or footwear, because the price is not expensive, and lots of clients use OEM factory in China. So how to get to know which one is genuine, which one is a counterfeit is a bigger challenge for our local investigator and also for our own informant. So you need to disclose more or less some simple verification method or train them to do some verification so that they can quickly find the counterfeit for you. And then meanwhile, it's very important to have a 2-layer of verification method. So 1 layer is to disclose to the outside, like an informant or in-house investigator. The other layer should be controlled by yourself.
Speaking just 1 minute, because we have very less time left. We need to, if we can finish it off in a couple of minutes. Yeah.
Yeah. And the last part is attending fashion show and exhibition to find the suspicious counterfeit. The third part is voter protection. So if you have a record, your trademark, patent, and copyright, you should, second step, record your authorized factories. And then if you routinely do office custom official training, then you have a better feedback from border official as well. So we arrange lots of border training course like twice a year in China to help our client to to have a strong support from China custom. So this is actually the strategy I mentioned already. You have a, so this is more vivid, I think, from market, from online, from outline, or from border protection perspective, you can differentiate small fish and big fish, and you take different action. One is cost effective, and the other is a very, could be relatively expensive because you have a civil action or PSV. So that's the picture for the strategy I just mentioned. This is the very case we just concluded this March. This is for campaign for our client Heinz brand. So in this case, this guy is put in prison for 4 years, no detention, just imprisonment 4 years. So for infringement of the trademarks. So this is a very example where to show so long you have a good strategy, so long you can mobilize all your resources and using a good, qualified law firm, you can have a better case in China. And I think from that context, KNS and our firm, if we work together closely, we can have lots of very good enforcement case. So as a conclusion, there are 4 channels to take action in China. You can file ISP complaint through Alibaba, Taobao, JD. You can file administrative authority. You can file a complaint before administrative authorities to take enforcement to stop the infringement. And it's a balance of strategy because you cannot stop, if you cannot stop them permanently, it's better you have like a civil criminal case at least once a year or 3 years, every 3 years, to let the infringer know this is dangerous business, don't do that. So I think that's a balanced strategy and the border protection. So when we talk about the 4 methods, we're not talking about just one. We are talking about a balanced strategy to make sure you are not only stopping the infringement from the end user, but also stop them from the judicial or business hard, concept perspective. So we hope to support you in China. Our firm, we have 350 members, 8 offices in Greater China, and we have liaisons US, Japan, and South Korea. We have a long-term experience working for prosecuting of IPR and also for the enforcement work. So we hope if you need our help through K&S, we have a very long-term cooperation. We can give you a better strategy in China. So that's it. Thank you.
Thank you, Spring. Thank you, Spring. And now I'll quickly request Bhawana, because we have very less time left. Bhawana, if you can, I know it is difficult, but try to finish it up as early as possible. Kavita and Akshay, I think we need to extend the time a little bit, 10-15 minutes. So instead of 2 o'clock, we may have to start by 2:15 the panel discussion. Over to you, Bhawana.
Yeah, thank you, Goutam. I'll just quickly share my screen.
And one thing, Spring, if you can share the presentation, because we need to share with all the participants. If the presentation, the copy of the presentation needs to be shared. So yeah.
Sure, no problem.
So is my screen visible?
Yes.
Yeah, okay. So firstly, good afternoon, everyone. So I'll be talking about how design protection can bring value. So to begin with, be it high fashion or ready to wear, the fashion industry at heart is not just about the business of fashion, but it's more about companies' intellectual capital that creates a trend. So the intellectual capital is nothing but the value of creative assets and the brand that makes that asset. So as a fashion industry is a very IP intensive industry, a company's ability to build a strong IP and to monetize a unique brand is very crucial to achieve a competitive edge essentially for its success. So let's understand the overview of industrial design registration. So when considering IP in fashion industry, so design plays an enormous role in proliferation of fashion. So let's understand what an industrial design means. So under Section 2D of the Indian Design Act, so design basically means about features of shape, configuration, pattern, composition of lines or colors, but it is applied to any 2-dimensional or 3-dimensional form, and it is produced by any industrial process. So when the finished product is there, it should be like appealing, and it is judged solely by an eye. So it simply means that aesthetic appearance of an article. So the design protection of design is in for 10 years from the date of registration in India, and it can be extended for a period of 5 years. So once this period is expires, then the design falls in public domain and may be used unrestricted by anyone. So then now designs are generally classified, the goods are classified, and it is applied based on its nature. So there are 32 classes in total, and most of the classes are further divided into multiple subclasses. So as an example, if you can see, these are few registered designs when it comes to fashion industry. Let's say we can apply design registration for apparels, textile fabrics, jewelry, footwear, and handbags. And another important key aspect is that the design of an article of its packaging are important for commercial point of view. So an article is distinguished not only by its utility, but by its visual appeal. So which too, plays an important role in shaping the buyer's preference of the article. So therefore, designs can also be registered. So as an example, here is this image illustrates the evolution of packaging of Nivea's body lotion. So moving forward, I will now highlight about the prerequisites for a design registration. So firstly, the design should be new and original, and any design which is significantly should be distinguishable from the known designs. And it should be applicable to a functional article, and that means visible on a finished article. So before filing any design registration, there should be no prior publication of or disclosure in the design in public in India or elsewhere in the world in any tangible form, let's say like brochures, advertisements, or any other publication in websites, e-commerce platforms, social media handles. So now moving on, let's see what a design excludes. So firstly, design does not include any method of principle of construction or anything which is mere mechanical device. Just to give a more, as an example, let's take a wristwatch. So the outer shape, contour, appearance of the watch can be protected under design registration. However, the way it works, the internal mechanical or electronic components within the watch are excluded from the design protection. Secondly, the designs also does not include any trademark. That means the shoe design, which you see here, has the company's logo, let's say DSC. So how this design registration only covers protection to aesthetic appearance of the art. But whereas the trademark, that is the logo which is present, is not protected. So further, designs also should not include any obscene or scandalous content in them. Finally, the artistic work is also excluded from protection as design. Artistic work is excluded as it falls in the category of copyright protection. So let's understand what is the dilemma of design versus copyright, which generally exists. So copyright and design registration are two different areas of law that you use to protect your artistic work. So there are a number of differences between copyrights and design protection. Unfortunately, you can usually rely only on one of the IP. So it's very important to understand these differences that you choose the appropriate type of protection. So to be simple, copyright protection is granted to a work of a pure art. So let's see what is pure art is. Pure art can be defined as an original expression of the author and devoid of commercialism. For example, copyright protects paintings, videos, photography, sculpture works, literature, and many more. So copyright protection aims to prevent the exploitation of author's work by others. And the only essential requirement of copyright protection that it must be original and it must not be copied. So it is pertinent to know that according to Section 15(2) of the Copyrights Act, copyrights only protect the artist not being commercially exploited. So this means that you will lose your copyright in a design that you have industrially applied if a design is applied to more than 50 items. It will be considered as industrially applied and your copyright will cease to exist. And then here comes the picture of Designs Act. So on the other hand, designs can be protected under Designs Act that can be commercially viable. You can produce it through you can commercialize your work. So as an example, let me tell you. So here is the famous Leonardo da Vinci inherently have copyright protection on his Mona Lisa's painting. However, if Leonardo wants to materialize his painting into a bed sheet, and it starts to, he starts to mass produce and reproduce these bed sheets, the copyright protection on the bed sheet will exist, but up to 50 bed sheets, post which the copyright protection will be ceased to exist. So in that matter, so Leonardo must have design protection if he wishes to commercialize his artistic bed sheets. So this is the importance of design registrations comes into picture. So now I'll present a case which was dealt with in interplay between the copyright and design. So here in this case, microfibers, some original artistic patterns, and use this prints on their upholstery fabrics. There is Giridhar, also in the business of manufacturing and selling upholstery, comes out with similar prints on the fabrics. So this leads, microfiber to allege copyright infringement and passing off Giridhar. And Giridhar countered that, producing the arguments that works of microfiber are not even considered as artistic work and are not worthy of copyright, but rather it has to be protected under design, under a design act. So here, because they produced this, they countered this because they said microfiber had used their artistic patterns on the upholstery fabric, and they started reproducing and reproduced as more than 50 items. So that is the counter of Giridhar. And then Delhi High Court agreed to the this statement provided by Giridhar. And then they said that though fabrics of Giridhar did incorporate designs founded on artistic patterns belonging to microfiber, but because microfibers were meant for commercial exploitation, they were using it for the prints were being used for commercial exploitation. Therefore, they were not qualified for copyright, but under design protection. Also, in the absence of the design registration, microfibers was not entitled to any relief. So in a similar way, there was a recent case of Ritika Private Limited versus Biba Apparels. The court found microfibers and indicated the importance of design registration for industrially produced clothing and designs. And now we know that, like referring to this interplay and the case study, let me tell you some key takeaways, which, let's say, for example, throughout the world, the biggest challenge faced by the fashion industry is the rampant piracy. So if you plan to make multiple copies of manufacturing any fashion product, please do consider registering your design. So thereby the registered proprietor of the design can sue for infringement and he can enforce his rights. And if his or her rights are infringed by anyone, that would be a very viable option. And also, similar to all other IPs, design registration can generate income for its proprietor by way of licensing or assigning his or her designs as legal property, or by obtaining considerable royalty. Also, within the courts, putting more emphasis based on the case studies, they're so much emphasizing on the design protection. So that on the provisions of the Design Act and the mandatory requirement of registration. So companies in fashion industry should register their design so that unauthorized copying can be suitably tackled. So, so these are the basic, I can say, the key takeaways we can take it up when it there is a dilemma of copyright and designs. Yeah, these were my, overview. So over to you, Goutam.
Yeah, thank you, Bhavna. Thank you so much for managing your time so well. So now I request Ashish to take over. Over to you, Ashish.
Hi, Gautam. So I have 12 minutes. Okay, just share my screen. Can you guys see
No.
my screen?
Yes.
Yes? Okay.
Yes.
Quickly. Afternoon to all. So this is something which Elisabetta has already spoken, and maybe I don't need to stress on it. So trademark, word, logo, shape, packaging, combination of color, sound, smell. It acts like a source identifier, distinguishing the goods and services of the provider. What does it mean? I mean, what does a trademark mean actually? It conveys a proposition to a consumer, a certain value, a standard, a quality. It kind of builds a goodwill, and most importantly, it's an asset. So the different types of trademarks which are there. You have the word, you have the logos. I've put it in a collage so you can have a quick view on it. And here are some non-traditional trademarks. As you've seen in the previous slide shared by Elisabetta. Here you have Adidas, you have Crocs, you have the jeans, stitch design pocket, which is basically Levi's. You have the bags, you have the perfume shape bottle, and you have the Louis Vuitton pattern. These are all registered in India as of today. So one interesting thing I would like to bring to everyone's knowledge, which I believe most of them are already aware. Everyone knows by looking at the picture of what I'm referring to, but this is basically what they have trademarked, the white sari with the 3 blue borders by the nuns of the Missionaries of Charity. So this is also registered as of today. Apart from trademarks, you've heard copyright, you've heard designs. There's something even in the fabric or even the fashion world, something to do with geographical indications. Obviously, everyone, to give you a hindsight what geographical indications are, it's something of an indicator to indicate that this particular good belongs from a particular region, or it comprises of certain quality and has some kind of reputation associated with it. And just to give you a kind of an analogy, you have Darjeeling tea, you know it belongs from the region of Darjeeling. You have basmati rice. There's no region basmati, but the quality of the rice is basmati, and there is a defined area. Similarly, here you have the shawl from Pashmina shawl from Jammu and Kashmir. You have this Muga silk from Assam. And as you see, the name Assam doesn't come, but it's just called Munga silk. And then you have Kolhapuri, obviously the name, and you have the Konari shawl from Himachal. Now, while everyone has spoken about some aspects of trademark, some important things you need to know, that obviously this is a TM symbol, which is kind of a indicator that the mark, that particular mark is a trademark. And there's no prohibition of use of this TM symbol. There has been a misconception, which I've seen in many, that they feel that they can use a TM symbol only after they have filed a formal application before the trademark office. Well, that's incorrect. You can use it immediately the day you conceive the mark. However, then there is this registered symbol, R symbol. Now, this indicates it is a registered mark. And if you use it against an unregistered mark, then it is actually a criminal offense. So moving ahead, now people feel that, registration of a trademark is mandatory. Sometimes this is a misconception again, because it is actually not mandatory. But what registration helps is actually enforcing your rights, or even proving that this mark belongs to you. So if you are not a registered trademark holder, then you have something called common law rights. And that rights has been acquired based on your commercial use of the particular trademark. And once you obtain a registration, then you have something called statutory rights, which is through registration. But primarily, common law rights are more superior than your statutory rights in terms of what, if you are a prior user of a trademark, and if you don't even have a registration, a subsequent trademark registered holder cannot stop you. So that's one very important aspect. And as I said, the registration certificate is simply an indicator that yes, I am the owner. And it helps because sometimes you have to actually come out with lots of documentation, document of invoice, of your incorporation certificate, or any other advertisements that you may have kind of published to indicate that the trademark belongs to you. So jumping straight to the enforcement aspect, I thought it would be relevant to give you a kind of a chart to explain that in enforcement, maybe we're looking at civil, criminal, and border control. Now in the patents, you have the option of civil, but there's no available option for criminal or border control. Trademarks, you have all three options: civil, criminal, border. Design, you'll have civil and border. Copyright, you have again all three options, so as geographical indications. Now in civil, what we talk about is obviously you file a civil suit before the court, and you kind of have a defendant who is the infringer, and you ask the court for an injunction or a temporary restraint for the defendant to stop using of the mark, and subsequently and in the end of the suit becomes a permanent injunction. And then you have recovery of damages, and then follows the destruction. In criminal, you kind of seek a complaint either in the court or in the police, and then the police investigates and there's a prosecution, and the end consequences, obviously there's imprisonment or fine. Again, there's a destruction of goods as well. In border control, you have a situation where you record your IP, trademarks, your designs, your copyright, and geographical indications. But I may add here that in border control, you must have a registration. There is no procedure involved where you can record an unregistered IP. You should have a trademark registration or a copyright or design or a GI registration to record yourself. And then the custom authorities stops all imports that come into India based on your registration and recording. And obviously you have the administrative remedy, which is specific to the trademark office or the registrar of companies. For example, if someone were to use your trademark in the name or part of a name of a company, then you have an option to go to registrar of companies and file for cancellation. Similarly, even for a domain name dispute, if someone has copied your trademark and created a domain, that as well, you have an option to go to either the .in dispute resolution policy or uniform dispute resolution policy, depending on the extension .com, .in, or whichever. So just to go a bit more into the civil remedy. So this is something that you can file before the district court, commercial court, or the high court, depending which has original jurisdiction. So where to file is something the jurisdiction rules will apply. Under the trademarks, you have section 134, where you can apply even if you're a trademark holder, where you reside. Otherwise, the relevant provisions of the Code of Civil Procedure will apply wherever the cause of action has arisen, where the defendant resides. And as we all know, there is obviously a long process before arrival of a final judgment. And because there is a long process, there is something called interim injunction that one can apply for immediately at the time of filing of the suit, so that the defendant is restrained from using the mark till the disposal of the suit. And obviously the appeals go all the way to the Supreme Court of India. Now, the interim measures, as I said, you can have an interim injunction because the suit takes very long, so you can expect delays. So it's better to apply for interim. And there are two types. You can get an ex parte interim injunction, wherein even on at the very first day of your suit, you are able to, if you are able to convince the court that the defendant is actually blatantly violating your right, and you have been able to show that the balance of convenience is in your favor, then you may be able to get the ex parte injunction. Now, also it's the term or the time within which an interim injunction. So there are two types. One is ex parte interim injunction and one is the interim injunction. Now, ex parte interim injunction means in the absence of the defendant. Ex parte means that. And interim injunction means the other side also files a reply to your application for interim injunction. And then that usually takes around 6 months to a year, usually. But that also depends from jurisdiction to jurisdiction. So, as I said, there's an ex parte injunction system where you can get at the very first hearing. There's something called also an appointment of local commissioner. Now, it's good that you get an order, but like a paper tiger, and then you don't do anything with it. So there's an option where you actually go and even apply for local commissioner to say that, this person visit the premise of the infringer. He looks at he searches the premise, and then he makes an inventory of all the products which are infringing, and then kinds of prepares a report which is submitted to the court. Now, all the materials that are seized at that time, they're actually kind of packed up, and they kind of sealed and left with the defendant under his supervision. And he's not supposed to touch it unless he gets a prior permission from the court. So just to give you some a picture of how they do it. So if on the left you see, there is this, he is a local commissioner appointed by the court. Now he has packed some shoes here, which are counterfeits. And after he's packed it, he's made an inventory. Now he's sealed it. After he seals it, then on the right, you see this is box number 3. These are the contents of the box. And then he writes his name, because the local commissioner can be anyone, even a lawyer who's appointed by the court, or even a court administrative officer. So it all depends on who the court appoints. And then you seal it up and you leave it like this with the defendant. And then as and when required, called by the court, this should be produced. So just to give you some kind of cases that's happened, like for instance, this was gap and the defendant was using gap in. Now please see, simply using in or off or good, it's like using, your credit card. You have a gold standard, you have platinum standard. It does not add to the distinctive character or value of the mark. So therefore, by using these terminologies, which are very generic in term and which are simply laudatory, will not help you. In fact, these are the marks that actually get you in trouble if you do this. So similarly here, gap in was something which the court kind of refrained the defendant from. This is something which you've already must have heard in the news, that this shoe, obviously all of you must be aware, is famous for its red soles. And the Delhi High Court has passed around 2 to 3 orders in these matters, wherein it has also upheld that the red sole has acquired a well-known character. Though there was an instance in one of the cases where it was the single judge of the High Court was not inclined to pass, but then it went to the division bench and then it's come back. So there's where it stands. So there is something called an interesting case here where we have the Mercedes logo, which was actually used for undergarments. And in this undergarments, they had a nice slogan here, German perfection. It need not be restricted to mere machines or horizons. So here the court as well said that, look, though they are not in the same business, but the symbol is very well known. and it needs to be protected even in respect of dissimilar goods or services. Now, coming to another case, which also I'd like to show, is Sony. Now, this person was actually using Sony for lungis. The court even here held that, Sony is a well-known mark. Even if they are in a diverse field, this mark has acquired a reputation and needs to be protected. So we have another case, which is H&M. This person was using H&M mega brands. The important part of this case is, even before H&M entered into India or had official stores into India, the defendant had already started using it. However, the court observed, if you see the second bullet, plaintiff's entry into subsequent is irrelevant. Increased foreign travel and exchange of cultures, consumers aware of top brands worldwide. Meaning the reputation of H&M, despite not having an official store in India, its knowledge, as now you would call it transborder or spillover reputation, was so high that even if this guy had opened it initially, he still stopped. So they were restrained. And just to give you a highlight, this is the latest, one of the latest, where sanitizers were being sold rapidly. And so in this case also there was Dettol versus Dettol. Here again the court restrained. So now I just quickly touch over the criminal remedy. Now the offenses is falsification of trademark. The term counterfeit is not there in the statute. It's just a term which you use in common parlance, but it is not there. They use the term falsification of trademark, which in a way comprises all the characteristics and all the manners in which it can be construed to be counterfeit. So there's imprisonment, there's fine, and obviously enhanced penalty of. So what do you do is you can file a complaint with the police. In a trademark matter, there's a provision under section 1154 proviso, wherein you have to seek the opinion of the registrar before the police takes an action. That is for the reason the police is an investigating agency and not an adjudicating body. Therefore, the registrar would need to give an opinion to say what has been complained is correct or not. And the police is bound or mandatorily required to follow that. The other one is obviously go to the magistrate, you get a search and seizure warrant, and there's no requirement for registrar's opinion. FIR is registered, there's search and seizure, and then the charge sheet is filed and criminal trial commences. So just to give you another misconception, people say that it is available only for registered marks, not available for unregistered marks. But way back in 1972, the Supreme Court clearly identified that even unregistered trademarks can have the option of conducting criminal enforcement. Now, while there is a possibility, and the Act does provide that solution, however, practically there is a difficulty because you need to show documents how you are the owner. So there are practical challenges, but the law does provide so. Some pictures here of the raids that were conducted in India. If you see here on the left is the factory, and these are some jeans that were actually confiscated. Again, these are the machines. And let me tell you, when the raids are, even the labels, even the machinery that is used, all of them are confiscated. Anything which is used for packaging, which is used for embossing the mark, those all would be confiscated. And to just give you a kind of a picture of how the factories look like, this is how those jeans were actually made. Look at the quality or the manner in which it is being made. So that's it from my side, Goutam.
Yeah, thanks, Ashish. So Kavita, you have an announcement.
How do I stop this one?
Kavita, are you there? So since I think there is some technical glitch.
Yeah, hi, Goutam.
Okay. So quickly, if you can announce how to respond to the questions.
Yes, so because we are short on time and due to the paucity, I'm requesting all speakers to please respond to your answers question to you directly on the Q&A box, and any other information that you would like to share. It'll be helpful if you can send it over the Q&A box. Thank you. And Gautam, over to you for the panel discussion now.
Yes, we can save some time. In fact, all the questions, I have seen the questions, those are directed questions to the speakers, and in the same box, it can be replied. Okay, so now over to the panel discussion. So just a second, let me find out the names, brief profile. Okay. So I'll just set the context and then I'll hand it over to the eminent speakers from the industry. In the current business environment, the primary source of competitive advantage for all business, even it is including for the fashion industry, is innovation and original. I'm sorry. Original creative expression. It is imperative to identify such valuable and intangible asset in a timely manner and determine their business relevance and agree to those to be protected and leveraged through intellectual property system. So I think in the second part of our session, on the session 2, we'll be speaking on the IP strategy and also in the some of those practice pointers during this digital economy. I would like to introduce speakers. We have 3 eminent speakers here. So Jyothi VK, she is General Counsel, Vice President, Aditya Birla Fashion and Retail Limited. In the role of General Counsel, Jyothi heads legal function of Aditya Birla Fashion and Retail Limited, a public listed company which is a leader in fashion and lifestyle space in India and export territories in Asia through its reputed brand like Louis Philippe, Allen Solly, Peter England, Pantaloon, and People. She is responsible for legal risk management and legal affairs across diverse business of Aditya Birla Fashion Retail Limited and works closely with senior management on strategic decision and governance. I would like to introduce now Dr. Jitendra, Jagota Director, Legal and Government Affairs, Avon. Mr. Jitendra is presently handling the legal challenges of direct sell industry while working as Director Legal and Government Affairs with Avon Beauty Product. He has been supporting the cause of industry as an active member of Executive Committee of Indian Direct Selling Association and core member of Direct Selling Task Force at FICCI for last 7 years. FICCI is for the understanding of my colleagues from Italy and China. It's Federation of Indian Chamber of Commerce. He served as a chairman of IDSA during 2016 and 17, the period during which the much awaited direct selling guideline 2016 was issued by Ministry of Consumer Affairs. And I'll also take this opportunity to introduce one of the eminent speakers from NIFT, Dr. Deepak Joshi, will present his post the panel discussion. He will share his thought, but let me introduce him right now. He is currently assistant professor at FMS NIFT-Delhi and unit in charge IPR NIFT and MFM alumna of NIFT, UGC NET Management Qualified, PhD in Management. From IIM, over 13 years of experience in corporate and academics. His interest is in marketing, consumer behavior, retail management, and business analytics. Sorry. So let us start our discussion on IP strategy. So my first question is for both Jyothi and Jitendra on the IP strategy. What is the basic framework for devising your IP strategy? Let us start with Jyothi, and then we'll come to Jitendra.
Thank you, Goutam. Good afternoon, everyone. Thanks to Lex Witness again for this opportunity. I think we have been having a lot of serious discussions around fashion, but fashion shouldn't be discussed so seriously. That's in a lighter vein. What does fashion mean? All of us know it's very dear to our heart. You can't really define in one way. It lets you celebrate your individuality. Well, but when a fashion product is in front of you, you might see the frills, the colors, the design, the patterns, and the style. But legally, what you see there, a lawyer, is a bundle of intellectual property rights. It could be a patent, which is a process patent, or it could be a patent, it could be an invention. Most often it's a process patent as to how a fabric is made or how is it designed, things like that. And there will be a copyright, which is on the sketches, on the designs that you make, a trademark as to how you really identify your goods. That's your trademark law. And then your designs, basically when you apply industrial process. So what designs that go into that, and of course the geographical indications, if you associate yourself with the GI owners and produce any products. Well, ABFRL has already been introduced by Dr. Goutam. Thank you for that introduction. ABFRL is a fashion conglomerate. Of course, our IP portfolio itself consists of more than 1,500 trademarks. And then we have copyrights, patents, designs. And of course, our business extends to more than 3,000 stores across India. So one is, the protection of these, registration of these intellectual property rights, which we always see them as mandatory for ourselves. So be it a patent, be it a trademark, copyright, design, we do register. That's one. And second is, of course, your prosecution, you will have to ensure till it gets registered, you'll have to do all that it takes. And in the process, you'll also see many people filing some infringing marks. So you'll have to keep filing oppositions to them to stop them. So that's one part of it, which is like, I would say, the administrative part of the IP management, basically. And the other one is, the licensing, which is we license our marks to others for manufacture of some niche products. That's one. We also take license from international brands, like you'd have come across Ralph Lauren, American Eagle, Ted Baker. These are all our brands. We hold them as licensee. So that's one. And then, as I also told you, the geographical indications, we associate ourselves with GI owners. One is to help them. They do need the kind of publicity they need, big customer base. So you would have at least come across Alan Solly Ikat shirts, which was introduced a few years, about 2016-17. That was our unique experiment with Pochampalli Handloom Weavers Association. And that really became very popular. So that is a GI exercise. And besides this, we also protect our domain names. So this is all of it, if I were to put it in like one bag. And another one would be, what actions that we take around these. So the enforcement actions, it's civil actions, there's filing in court and criminal actions, going to police for seizures, raids, etc. And then the custom recordal of cases to stop the cross-border, the cross-border percolation of this counterfeit stuff. All of this is part of our IP strategy. And of course, with our vendors having unique contracts, robust contracts, and having appropriate IPR clauses with vendors, taking undertakings from them. And all of that is part of our IP strategy. Is there any?
Over to you, Jitendra, now on the same question. Also, I would like request you to add one more point, which I'll ask also Jyothi to share. In the strategy, how do you manage to leverage multiple rights as well? Because you have so many rights. Jyothi has also, of course, she has given her insight. I'm sorry, Jyothi, you have given your insight about geographical indication, design, and other thing. Over to you.
Yeah. Thank you very much for the wonderful introduction, Dr. Goutam. And it was really wonderful, listening to other speakers, on this board. So to give great insight about the trademark, design, copyright, and other IP rights. So far as Avon, where I work. So just for the information of the panelists, Avon is basically into beauty business. So I think most of you must be aware of. So be it largely, of course, cosmetic products, and apart from this, there are some accessories, for example, bags and some costume jewelry business where we are in. So it's about a 135-year-old company. So they've started heavily investing on protecting their information technology, be it patent or trademark or copyright. So largely, Avon is into these three categories. However, they have done a lot of innovation in the cosmetic products. So if I talk about the patent in that particular innovation, there would be about some more than 200 patents to the name of Avon, and most of these patents are more on the operation side or process side rather than the design patents. So currently there is some shift where even Avon is also considering going into design patent worldwide. So that is how it's very significant for Avon to have most of its mark registered. Primarily, one, of course, to give consumer also a sort of confidence in terms of making sure that quality product is going to them. And as Ashish was mentioning in his presentation, that trademark registration may not be mandatory. However, many authorities, of course, in India also it is the requirement, and in some other market also there is a requirement that when you start manufacturing any cosmetic product, it has to be registered under a particular trademark. Because under drugs and cosmetic, when you go for, let's say, product registration or a license to manufacture cosmetic products or Ayurvedic product, they oftenly ask for the proof of ownership of the trademark under which a particular product is going to be sold in India. So, and when they ask for the proof of ownership, the trademark registration is the only document generally they accept. And at the same time, when we really import some of the cosmetic products, so even during the importation process also, there is a requirement that they need some undertaking from the owner of the trademark that yes, this product is owned by so and so manufacturer. So when we import from a particular country, we get that undertaking from that country. So from that viewpoint, yes, registration of trademark is really play a significant role, and it's a very significant area for the beauty products, particularly the cosmetic products. So that is one aspect. And apart from this, of course, as Jyothi also mentioned about the strategy of how making sure that even all our vendors with whom we are working, they also respect our trademark, because many a times we need to outsource or some of our products. It's, of course, we have our own captive manufacturing facility in India, but many products are outsourced and got manufactured from a third-party manufacturer. So we have a very elaborate process where we take, we in fact provide some training also to these third-party, how they can really protect trademark, and what are the guidelines which they really need to comply with and ensure. And similarly, we have very robust program internally. This happens worldwide, where all the employees are also undergo a regular training in terms of understanding the importance of trademark and other IP rights of Avon. And even when any employee joins the organization, they have to give this kind of an undertaking, so that they understand the significance and importance of these IP rights. So this way we try and manage our IP portfolio and make sure that yes, of course, the registration of all the trademark and copyright is really something which we initiate immediately, and then we have a centralized team who ensure that these rights are duly protected against any kind of counterfeiting activities or infringement in any market, including of course in India. So so that is how we manage our IP portfolio. Thank you.
On mute, yeah. So thank you, Jitendra. Now we spoke about being infringed. Now, what are the? How do you ensure that you are not infringing others' fashion brand? In other words, what are the due diligence processes that you follow? The question is for to you as well as Jyothi.
Yeah, so not being infringing others' trademark is also very, very important aspect of managing IP, because infringement entails a lot of penalties apart from bad reputation in the market. So we really to make sure that we are not infringing this any of the IP of third party. So for that, as I mentioned, that first thing is that the employees generally we take undertaking from the employees whosoever is joining in, not to get into this aspect where they are sharing sometime out of probably do the things faster. They may share some of the proprietary information of the previous employer. So we specifically take undertaking that Avon never ask for these things, and we discourage them that they should not disclose such information to us. So that is one part where we make sure that we are not infringing. And of course, it's not a 100% foolproof mechanism available where we make sure that we are not infringing any rights altogether, because sometimes accidentally it may happen that there is we trespass on some or other aspect of the IP of a third party. Of course, then we need to be ready for that what kind of remedial action we can take to make sure that it is not or maybe making some sort of a provision to manage such eventualities. And of course, we have to thoroughly do the search through by appointing outside law firm who can help us in terms of giving us to the extent possible that yes, this particular mark or this particular design is available for registration.
Okay, over to you, Jyothi.
Yes, thank you. So, well, I must tell you, no offense meant to anybody here. When I used to talk to designers, they used to say that they're inspired. And I used to find it very difficult to kind of convince them, excuse me, this inspiration, what you're saying is actually copying. So please understand that the individuality of an the originality has to be protected. So you can't say that I got inspired and I created something similar and that you can't claim more rights for it. So of course, a lot of debates and discussions used to happen with the design team, but then, well, all of that is got streamlined into kind of well-designed processes now. So if any mark or any design has to go into the market, so generally it goes through legal, and the legal does a thorough search. And of course, we do journal searches, and of course, wherever required, most of the work happens in-house, but wherever required, we do go to external lawyers. We do a thorough search of all the, a similar or infringing or likely to infringe kind of marks, and then we take necessary actions. Either we advise a business to step back, or sometimes make necessary changes and then we go ahead with it. So that's the process that we have been following.
Mute. Yeah, thank you, Jyothi. And now we'll move to the digital platform. So you have seen that brand and consumer has embraced the online world, and especially the millennial crowd. Again, I was reading an article. They said there are about 20 million e-commerce stores selling products on the internet around the world today. And God knows what could be the revenue. It must be in a trillion. So now question to Jitendra, how do you deal with counterfeit product on e-commerce platform?
So yes, e-commerce, I mean, it's something which is, you really can't avoid, because the way it is growing and the way it is being, as you rightly mentioned, is popular amongst the millennials and the Z generation. So we really need to embrace e-commerce. Just a sec. Yeah, there is some work going on in our kitchen, so there was some strange sound. So I thought, let me take a pause. I'm so sorry for that. Yeah, so I'm saying that so we do see that a lot of counterfeiting products are coming up on the e-commerce platform, and because of it's so easy to approach, so easy to get closer to the consumer, and all these people who are doing the counterfeiting, and for them also it's very easy to come out in different form, or in different in disguise sometime. So if they stop selling in a particular platform, they'll pop up in some other place, or maybe in some other name also sometime. So it's indeed very difficult to manage so many infringer on this space. However, when we were grappling with this issue, we were start interacting with the Ministry of Consumer Affairs to come out with some specific regulation to manage this aspect. So as I mentioned, that we are in the direct selling business, so so we have so many women who are selling our products. So when they are selling our products, and it is more on one-to-one basis, when they are demonstrating a particular product and then they are selling it to their known one. Whereas when our products start getting sold on e-commerce platform, so it's created an issue for all the direct selling industry as such. So we and then one of the aspect of that our product being sold on the internet or on the digitally is that infringement of our trademark, because those products are being sold without, first of all, our consent, and at the same time the way it is being packaged, the way it is being shown over the internet, it's not giving the right image of the company. So then we approached, and there were some court cases also. In some matter, we got favorable decision from Delhi High Court. However, in some cases, we didn't get the favorable order. So then we approached even the ministry also to get some solution. And then fortunately, this direct selling guidelines got introduced in 2016, where it clearly says that the product of direct selling cannot be sold over online unless there is a consent taken from the direct selling company. So this gave us some breathing where we can protect. However, the e-commerce company played their card of getting safe harbor rule under IP Act, where they're saying that we are just the intermediary, so we are not responsible if someone is selling your product. Then we again approached Ministry of Consumer Affairs. So, and that was a time when even the new Consumer Protection Act in India is getting amended and getting introduced. So at that time, again there were a lot of discussion happened, and ultimately the direct selling rules under this is soon going to be introduced, and the e-commerce rules has already been introduced. So under this new e-commerce rule, there is some protection where even the direct these e-commerce platform, these company has to necessarily give the detail of the sellers, and there is a clear cut mention that they cannot do any unfair practices, and also that they need to disclose all the details about the product. So now the consumer has the right to go for product liability cases against those who are selling counterfeit or infringing product or product of spurious quality. So this way the things are changing, but as still it's not a again 100% foolproof mechanism where we can get the protection. These things really need to be changed, or the amendment should keep coming into these regulation also, because the way the technology is advancing, it's not that only the companies or the industries having certain tools to protect its property. Even the infringer are also using those technology. They are much smarter than probably the industry, because they are probably thinking way ahead of the industry's things, and they immediately when you come out with some solution, so they are already ready to exploit that, and then come out with some or other technology where you still feel that, oh, I really need to now do something else. And all these things has its own cost, huge cost, to manage these situations. So somewhere what I personally feel that this regulation and firm guidelines or act really play a major role in terms of controlling infringement online. Thank you.
Yeah, thanks. We'll come to Jyothi on this more or less similar question, but yeah, Jitendra spoke about the regulation. Now, what are the gaps in the existing system? The legal gap, especially in terms of regulation to deal with the counterfeit, both offline and online. Over to you, Jyothi.
Yes, thank you, Goutam. Well, we should look at the challenges first before we come to what we expect from law. So I feel the fundamental challenge for IPR owners, especially in the apparel world or the fashion space, is people do not think that buying an infringed product is wrong. You often come across WhatsApp messages, I'm sure, that you will get a message saying that there is a Swarovski first copy. Actually, what does that first copy mean? It's nothing but a counterfeit. But it is being sold with so much of grace and respect that people really do not understand what's an original and what's a counterfeit product. So I guess it has to start with the culture first, because people, maybe we can start with awareness programs from schools and colleges to tell them that, listen, you need to protect the originality, you have to respect the owners who have created it, and please do not go for a fake product even if it comes cheap to you. So I think that's a cultural mindset that has to change. A lot of initiatives have to be taken in various walks of life, actually. It's just not legal. That's number one. Well, number two, administratively, if you see, there is no uniformity in procedures when it comes to infringement. Trademarks Act requires you to take a permission of a DYSP, but well, it is a sub-inspector under the Copyright Act. And you also have to take an opinion of the registrar in the Trademarks Act, but in the Copyright Act, it's just you can file it before an SI and get your infringement actions taken. Then comes the challenge of storage. So when you seize the products, what do you do with them? So most often the stations do not have that kind of space. And we had this unique challenge where the police had seized more than about 900 garments, and they were all Louis Philippe garments, and we had to, of course, we couldn't let them go to the market in any form. So we said we are going to keep them because the station didn't have space. So we kept it for so very long. But at some point in time, I had to face the wrath of my admin team saying that you are using so much of real estate space to keep this crap here. And when are you going to be done with this? But I didn't know what to do with it. And how long am I going to keep? Well, storage is a big issue. Then when you file these criminal cases, what you find is, the punishments, as already Ashish has taken you through, it is like 6 months, minimum 6 months to 3 years. Whether it's a trademark or a copyright. Of course, there's no criminal action under the design itself, nor under the patents, basically. So what does that do to you, basically? If you look at it, you actually, this become bailable offenses, and then the guy, the accused, gets bail within no time. And you will be very busy spending money, time, energy, going after filing these cases and prosecuting them. But while that guy is very happy, merrily, walking on the road, maybe laughing at you, at our foolishness, saying that, hey, what did you guys do? Look at me. And he'll probably start at another brand and then start doing his work and start making money also. But while we'll be still struggling on to get him charge sheeted. So they get bail so because of the 3-year thing, so they get bail. And not just that, under 437 CRPC, if there is, the investigation goes beyond 60 days, they get acquittal orders also. So there are a lot of these kind of challenges, basically, which weakens the very process of enforcement, and in fact dilutes all the efforts taken by the IP owners. And basically it erodes the faith in the IP ownership. And probably people will start thinking that there's nothing that you can do. So it's better we live the life the way we want, and we infringe others, like Gino though, like, you infringe others and let others also infringe you, because they don't have the faith in the system, looking at the way things are going around. So I feel going forward, what we should seek from the government, of course, besides what I talked about, the cultural change, is of course appropriate amendments to laws, to probably enhance the penal punishment, probably can make it more stringent. That's one way. But then I know that there are my friends on the other side, they say that, hey, listen, these are the days when people are opposing the punishment. They do not want punishments. They want to probably make it probably just a monetary penalty. So be it. Make it a very high monetary. If there is a very high penalty, probably that's also one thing that will discourage people from infringing your products. And especially when they are seized and that on the face of it, these are infringing products, and also the guy has no explanation to give. He probably has to deposit so much of money, so that that much of money is lying with the system while we prosecute these matters. So some kind of a monetary pressure is required to make him serious and also prevent him from doing further such things. That's very important. And another thing that I've noticed is the cops do not have sufficient motivation to help you. And well, it may be different in cities like Bangalore or metropolitan cities, but then when you go to smaller towns, and that is where a lot of counterfeiting happens. And when you go there to the police, I don't want to quote somebody, but then I still, I should say that even once, as like the court official said, "What's your problem, madam?" He let him also, like it's his livelihood. So, so that's the kind of people do not really understand the importance of the IPR. So they don't give you the, the required support. The cops do not think that it's very important to give you all the support, because for them, probably providing security, VIP security, or attending to important things or some crime cases is more important to them than coming and, spending their day with you to just probably seize hundreds of shirts for you, which they feel is totally immaterial or totally non-significant. I would draw some references to some good practices happening in the custom, department. So where they are incentivized, the officials are incentivized to do that. So that also keeps them going. And then if we are able to kind of, bring in a system where the police are not just motivated, they are incentivized to, go for anti-counterfeit actions, probably that will change the way we look at, the infringement actions. And then I think the most important thing I have been actually experiencing is we do not have a common data system at the national level. And nor do these agencies speak to each other. Like the customs has all these money agencies are sitting on humongous amount of data, but they don't speak to each other. It means the data is not exchanged and not used in the national interest. So I would say that something like on the lines of US IPR Coordination Center, which has representation of all the effective, they have the strategies to fight counterfeit, because they do recognize it as a very grave offense. So something like that is required in India, wherein the police, the regional police or is a state police, and then the customs, the revenue guys, and the various departments who get into they are involved in taking actions, should come together, and there should be a data coordination center and national data coordination center, which will bring together all this data, and that data can be effectively used to curb counterfeiting. So just to sum up, I would say that, we need, solutions, like multi-pronged solutions, cultural mindset, administrative changes, maybe at the police or the courts, because courts, you see, I'm sure most of the time you have the commercial courts, but the commercial courts are not even established in many places. So that's also, it's an impeding factor why you cannot really get your damages in these courts and all of that. Tribunals are not established. I know the appellate tribunal took so long to establish. So you can see all these kind of administrative things happening. You need, and a lot of funding has to go into setting up these tribunals, courts, effective functioning of these courts. That's on the administrative front. And of course, the National Data Center, I said, wherein the data is utilized in the interest of the nation to curb counterfeiting menace. And then, of course, appropriate suitable changes or amendments to the laws. Maybe I'd said like trademark, copyright, design, whatever. You look at probably increasing the penalties, or probably making it very monetarily tight for the counterfeiters so they don't do it again. So whether it is an online or offline, it should not matter much to me, because it should not match to others also, because the outcome is the same. The output or the impact or the implications for the society is the same. And it's so unfortunate in the fashion industry, since wearing an infringed product does not endanger your safety or probably cause any kind of immediate discomfort, probably it is not taken so serious. Probably Jitendra has a better case with him, because he can say that, hey, mine are cosmetic products, and somebody uses a fake product, you can end up burning his face or whatever it is. But then unfortunately, my case gets weakened, because I cannot say that somebody wearing a counterfeit Louis Philippe product got probably so annoyed or damaged or whatever it is. So, but I think it's all about protecting just not the originality of the products. You should look at the big picture, because most often the funding that goes into the funds received from these sale of counterfeit products are often used for anti-national activities. So I guess this has a very big impact on the nation's economy and national security as well. So I think if we look at all of these things, and my request would be if we can make a white paper and then submit to the government, and not just us, like we should get our tribe should grow, and we should really we should get these changes. And that's when we will all enjoy, the ownership of the IPRs.
Okay.
Otherwise, most of the times we'll be only battling in courts.
So just want to add, what Jyothi was mentioning about the administrative challenges, in particularly when it comes to taking police action. So I was just thinking, like we have a separate cyber security cell now, which takes care of most of the cyber incident or data privacy related incident. So similar to that, I mean, if there can be a dedicated or a separate cell for even IP protection as well, so that this police may not have that excuse which Jyothi was mentioning of providing some security and all. If there's some dedicated force only to, and they will be a little more aware of this issue and more probably updated and educated on the front of understanding, what the IP protection is, that will help in terms of, swift and effective action.
Thank you.
Just to add to that, there is a specific department which is called the Economic Offence Wing. However, they also do other things. But you are right. Within that Economic Offence Wing, they would have a specific team to do it. Like you have the District Investigation Unit, or you have the other such units which are there in different states. They operate in a different manner. Now, if they have a dedicated team, and this proposal was also sent to CPAM, which is basically the central cell of IPR promotion and management, for which we really work with a lot in terms of how we go to the police academy, state police academy, or even the IPS police academy, and tell them the importance of what are the issues that you should look at. We can understand, like how Jyothi said, murder is more important. Someone's car got stolen. That's more important as compared to, oh, this guy is selling duplicate cap. And you can see that there is a kind of an inclination now. But yes, we've got a long way to go. But yeah, it's a very good proposal. But we'll have to see the logistics available at them as well. They also are very hard tight at logistics there themselves.
So Ashish, yeah, that's actually one of the limiting factors, of course. But then when it becomes, a center of attention, or basically when the government focuses on this or recognizes this as an offense which actually threatens the national economy and national security, and then it kind of trickles down, then I'm sure it will make all things will fall in place. All things will fall in place. Any change that we have seen in the last few years, you would have seen. Even the GST was opposed so much. Even computerization 20 years back was opposed so much. But then you can see that we all have their limitations, but everything will fall in place when we have, a national perspective to it.
Okay, again, we are running short of time. We have so many questions, but I can't resist myself to ask 3 questions, one for Jitendra, one for Bhawana, one for Ashish, and request you to give a very brief answer. So, prevention is better than cure. And now you have to be really vigilant to protect your mark. So now, as Jitendra mentioned, that they are much smarter. So what are the tools that we are using, Jitendra, you are using in your company to remain vigilant? Over to you, Jitendra.
Yeah. So when you say tools, basically, this is largely, in the space of, online protection and e-commerce platform. So just to make sure that, those counterfeiting or infringement doesn't happen so rampantly, we started introducing the tagging system. And there was some watermark, a specific watermark was, we started putting on most of the product so that we can make a clear distinction between, what is genuine and what is, counterfeit. But, over a period of time, what we realized that even that also started getting, tampered with. And so again, the situation is that, how to really deal with it. Of course, it's not that it's happening too much, but then to some extent, even that activity is also happening. So, and apart from this, the other tools may not be relevant for us, but maybe, generally to the industry is like, for, again, protection, in the online spaces like cryptography or making use of the blockchain. Of course, I'm not the subject matter expert for the blockchain, but I've read so many articles that the blockchain technology can really help protect even some of the IP, including patent and design marks. And then you have this digital signature attachment, to some of these products. The moment you copy, you get a notification. So on the online space, the moment you copy your product, you get a notification that so and so from so and so IP address, this has been copied. So these are the the tools which are available in the market. But at the same time, as I mentioned, it's not that they are 100% secure. There is a counter technology from the other side also available. But then yes, it actually deter the infringer, because even someone to invest in that technology required huge funding. So yes, to that extent, it really helps.
Yes, thank you, Jitendra. Just a very quick response to it. One of our clients from IIT Kanpur, they have filed an application where it creates millions of different surface, what you called, I forgot the terminology. So through which it is random generation of different kind of signature, e-signature, which is attached to a particular product. You cannot copy it. In no circumstances you can copy it. So of course we are also trying to match with the infringer, but nevertheless, over to you, Ashish, on one question that. I think that this particular question was asked by one of the attendees, whether design on a cloth or fabric can be protected under Copyright Act. I think Bhawana has given an answer as well as Spring, but if you want to quickly.
Yeah, so to me, right?
Yes.
Yeah, so it's what Bhawana said, is section 15, the Copyright Act. So that particular whatever design or whatever pattern or whatever thing he is referring to has to come within the ambit of first the definition of artistic work, because copyright protects certain type of works, artistic, musical, cinematographic, photograph. So if it comes within artistic, and then under section 15 it indicates that if it is registered as a design under the Design Act, then obviously copyright is not there. But if it is an artistic work which is capable of being registered as a design, but it is not registered under the Design Act, then as soon as there is a 50 reproduction by industrial process, I'm repeating, 50 reproduction of industrial process. It's very important, industrial process, I'm not talking about the one, because see, if you draw a painting of even an apple, every time you draw the apple with your own hand, there's going to be a deviation. But if you do it in industrial process, it's going to be identical. So that's why I say 50 reproduction, 50 times through industrial process, you lose protection. So that's, I think, the answer to his.
Okay, thank you. Last question to Bhawana is now in a suit of infringement, you need evidences. So as an attorney, how do you gather evidences?
Okay, thanks for the question, Goutam. So we can collect electronic evidences like that can be generated or stored and transmitted, which can be retrieved from e-commerce platforms or social media handles, either videos or even emails, for that matter of fact. So if assuming there is no information available in the internet, then that is where we can use the optimum use of the IP investigators, who can do covert investigation and make some test purchases along with the cash memo. That would be beneficial. And also they will help us, they will visit the premises and collect financial data and click photographs or videos, and also communicating with the employees indirectly, and understand what type of products are being made in that particular company. That will also serve as a evidence, and we can do this submissions. Yeah, that's what I have I'm aware of. Yeah,
Just like to add to that, when you do these infringers, especially they do not give you documents, right? They do not keep inventory. They just make and chalo, gone. And they always do hard cash transaction. Sometimes so you need some document to show how you link that product with this person. If he's not in the net, he's not anywhere, how do you link it? So, we always do something called a notarial purchase. So you get a notary along, he comes with you, you go buy the product, he witnesses the entire transaction happening, you making an order, he giving it to you, and then you and he prepares a report. So you buy two products, one product is sealed in the notary report and one product you have with you. And that's submitted to the court, which is obviously at risk. The other is obviously you do a video recording, a sting operation.
Thank you, Ashish. Now, I would request Professor Deepak Joshi. So I sincerely apologize, sir, for some delay, but now I think we could manage a delay of only 15 minutes initially. So over to you, sir, for your closing remark and presentation of on NIFT.
Namaskar. It was a very interesting discussion going on, and it was quite enticing. So as Mrs. Spring was talking about big fish and small fish concept there, and even Dr. Jitendra Jagota was also telling about how the counterfeit products are reaching e-commerce. So India and China being one of the largest largest market in these terms. So it confirms that there are there is a supply chain of these kind of structured. So why this what to say supply chain is growing and counterfeiting products are being sold? So that is one of the questions which Ms. Jyothi was also answering, that there exists a chunk of people who are interested in buying these products. And why do we generally buy it? So one is the consumer aspect, that consumer doesn't knows that what he's buying, and he's not interested in brands. So one is that kind of consumer. So that consumer probably buys FMCG and all other items without having any intention towards brand. He's just buying a product for the use. He does not have a connotation towards a brand. But with the advent of so many resources and penetration of internet, even those people are getting reduced, and the awareness about brand is increasing. So what is happening, that as people are getting more and more aware about the brand, the inclination towards brand is increasing. And now certain researches have been done in different pockets of India, which have confirmed that within this specific segment of fashion, there exists a chunk who know that this product is counterfeit or false product, but they are interested in buying that. And that is a peculiar situation which might not exist in as Ms. Jyothi was also saying, that let's suppose that is a cosmetic product, or let there be a FMCG product, where knowingly I won't like to buy a counterfeit product. But in case of fashion products, be it apparels, be it many a time shoes, handbags, and even these are the categories which are having a highest share in the counterfeit products. Many of the customers are interested in buying these products. So that is one of the major problem which needs to be changed with respect of changing the mindset of the consumers or the customers. Now, as Ms. Jyothi was also adding, that we need to bring a cultural change. So how to bring that cultural change is an important task. And there the role of academics comes in. Even the latest IPR policy of India, which came in 2016, talks about raising awareness of general public towards IPR, and that is really important. Now, India being a signatory to TRIPS and having implemented the IPRs way back, many of the institutions came up with their own IPR policies in 2000s. 2010, around 2010. And even these policies, major of the policies are focused towards raising awareness towards how to protect your IP, how to identify the IPs, and how to reap the benefits of those. Again, we need a shift in that mindset, where we do not educate all the students from that perspective. Another perspective with respect to ethics about using the products, use of IPs needs to be inculcated. so that when all the consumers, or as an individual, I know that what IP is, and I know that if I'm using a counterfeit product, I should get from inside that, yes, I am doing wrong. And there have been certain researches which have proved that the person who have high lawfulness from inside, they are ethical, they do not buy, or they are less prone to the counterfeit products. And in fashion, the another basic difference is that these are aspirational products. They connote my identity or my social identity, which I want to have at a certain point of time. So people invest money knowingly that there is a counterfeit product, and that is not only going to impact the revenues or the brand image of the original brand, but at the same time, as Ms. Jyothi was also saying, that is impacting nation as well, and in a larger form, global economy as well. Even the latest report from International Chamber of Commerce indicates that by 2022, this counterfeiting and fake products industry is going to take away around $4.2 trillion from the global economy. And as per a latest report published in the Times of India around July 2020, says that it is the money going out from Indian economy with respect to these counterfeit products is 1 lakh crore. That turns out to be around 1,000 billion INR. That's a huge chunk which is going. And well said by Ms. Jyothi that most of this money is going into the crimes or the anti-national activities. And even an old report by ICC itself proves that. That says that the money coming out of counterfeit product annually, it was an old report in 2009. It said that it is increasing crime by 1% annually across the globe. So in addition to eroding money from the economy, giving rise to crime, and even risk of health to the people who are not only using it in fashion products, we can see that these where these products might be made are not conforming to the quality or standards that the companies which originally manufactures them or the factories which originally manufactures them follows. So many a times the workers working there are also prone to various kind of risks when they manufacture these kind of products. So it's not that only just brand image and the revenue of the brands are going off. It's a larger problem where entire society is being having negative impacts of these counterfeit products. The money which could have been gone through the tax system to the government, which could have been put on the education, put on the other social facilities like roads, schools, etc., is being diverted towards negative things like crimes. So whether I am an Indian or I am an American, if I'm a nationalist, I must, as a consumer, I need to take care that I do not buy these products. And that is going to only happen when the role of law and enforcement is put on one side. But inculcating these things in my inside, in my mind as an ethics is really important that academics has to take care of. And I was a couple of days back, I was just interacting with +2 student, and he was talking about a subject called information practices, which was supposed to be computer science kind of a subject. The CBSE has recently adopted IP into that. And he was telling that around, from the marks perspective, around 10% are allocated to IP. And that's a welcome move that our students have started getting knowledge of IP. And even the National IP Policy of India adopted in 2016 talks about raising awareness among general public. And as Ms. Jyothi was saying that it identifies that this national policy identifies that even the judicial system or the judiciary needs to be given this kind of perspective about IPR in much more important terms, so that even as Ms. Jyothi was talking about that, if you go to the distant parts, you do not get that kind of responses from the people who are responsible for it. So that mindset can only change when we start taking seriously as an academicians. not only in the higher level educations, but in the secondary level also. So I need to have an inclination that, as I think that stealing something is not true, I get a feeling from inside. That has to happen not only in these kind of products, but in counterfeit products. I should not be very proud when I put on some logo and walk with a counterfeit product. So that can only happen with the role of academic institutions. And another one is media. We see so many news daily for all whatnot. But as we discuss, so many interesting cases where we are being discussed, not only from outside, but from India as well. But general public does not know. The people do not know that if they are talking about certain things, being talked about infringement outside, that is not being discussed on media. So again, the media people who is a reporter, they need to have that inclination that yes, it is an important thing which must be reported, because it is, as we are saying, that most of the money that is being utilized is going into negative directions. So as an individual, as a countryman, it's my responsibility that I do not use counterfeit products. With respect to NIFT, we try to inculcate all these habits in our different subjects. We have a special subject called professional ethics, where we try to inculcate all these kind of ethics. And we expose our students to craft so that they get knowledge about traditional cultural expressions as well, craft, art, etc., etc. And our faculty are well versed with the design knowledge, and they impart the knowledge that how to differentiate, as Ms. Jyothi was very well saying, that people do not are not able to differentiate between what would be an inspiration and what will lead to a plagiarism. So that line has to be drawn somewhere. So as a leading institute of fashion in the country, we try to inculcate all these aspects into our students. So and one thing is that we tease them, and we inculcate all these things from the perspective that IPR is not just for you, that you are an owner and you reap benefits. IPR adds value to the lives of the people. It's the basic concept behind the IPR. So as an academician, as an individual, as a media, we all need to come together so that general public starts believing that IPRs are value-adding entities into our lives, and we must respect IPRs. And that will lead us to the concept, what we call in India as Loka Samasta Sukhina Bhavantu, meaning that let the entire world be a happy place to live in. Thank you so much.
Thank you so much, Professor Joshi. And I think that we come to an end of this the program. I request Kavita to give a vote of thanks and take it forward. Yeah, over to you, Kavita.
Thank you so much, Dr. Goutam. So I would like to thank all our distinguished speakers, NIFT, for their valuable contributions in this very important session today. I would also like to express my sincere gratitude to Lex Witness for the kind support in organizing this webinar. As part of our ongoing efforts towards creating IP awareness among faculty members and students of educational institutes, which is KNS Partners, CSR activity, and strengthening Indian IP ecosystem, we would be happy to conduct IP awareness session as and when required at NIFT for the students. And once again, many thanks to all the participants who joined us for this session. It was indeed a very engaging and insightful indeed. Thank you all. Stay safe, stay healthy, and have a nice weekend.
Thank you so much.
Thank you so much, Spring, and thank you so much, Elisabetta. And
Thank you.
Both of you are in Europe and you joined so early.
That's true. Indeed. I want to take this opportunity also to wish you all a happy festive season, And may the new year bring all of us, wherever we live, a better future.
Closing message from Spring. Anything you would like to share?
Thank you very much for having me, and I really appreciate our long-term cooperation and hope to strengthen our cooperation in China and India. Thank you very much.
Thank you. Thank you.
Thank you so much, everybody.
Bye-bye.
Kavita ma'am, seeking your permission
Thank
to
you
end the
very much.
webinar for everybody now.
Yes, please. Thank you so much. Thank you. Bye-bye.
For sure.
Thank you.
Thank
Bye-bye.
you so much.